the record?
We're back on.
Okay, we're back on. So you don't have an agreement because of... Okay. Because there's no agreement as to the interpretation of the order
No,
from
that's not
Missouri?
the case. It's not about the interpretation of the order. If you want me to be frank, the idea is that there's no give and take. So he really wants the child to have his last name and his last name only. He's willing to give her joint custody when she doesn't have it now. She's not willing to bend, and it just becomes an issue where
Okay, okay. You don't want to tell me about the negotiations.
Your Honor, I'm sorry, I don't know where we left off on the test.
I was on the stand, and I...
I think it's my cross. Or
Well, you called him.
I'm sorry, my
And then you
redirect.
asked your questions, you're done asking questions?
I have no more questions.
I have
So then
just
you
a
have redirect?
very short redirect.
Okay, all right, sir, if you would please come back to the witness stand. And then are there any other witnesses?
Not on our side.
Do you have any?
I could call his wife, but I don't know that she'll add anything.
You're still under oath, you can have the...
Procedurally, if the other side wants to simply add her without a clear division between the two case-in-chiefs, I have no objection to that.
He's not, you're not sure you're gonna call her?
I'm not sure I'm going to call.
Let's see where we go.
All right, so we're on redirect.
Good afternoon, sir. You last filed your financial disclosure form on August 18th, 2018. On or about
We haven't even gotten to August 18, 2018.
August 18, 2017. This past August, do you remember filing a financial disclosure form?
I do not.
That's the statement that says where you work, how much you make, what your assets are. Do you remember
I've done it
this?
a few times, but I don't know if I did one for.
Okay. The last one, I'll just help you out. The last one that was on file was mid-August.
Okay.
So have you changed jobs since mid-August 2017?
Yeah, we talked about that in court.
Where do you work now?
I sent you the email, the Timbisha Community Development Authority,
Thank you. And where is that located?
Death Valley Junction.
Do you earn about the same amount of money as you did at your other job, or is it different?
It should be more, but I haven't been paid in a while.
When did you start that job?
October 17.
That was about the time that the insurance changed for Emma.
Yeah, because the insurance ended when I left ARIA.
Do you have any work insurance, any employer subsidized insurance through your current employment?
I do not.
How do you have insurance for yourself?
We both, me and my daughter both do.
How is that? Through what form?
Through my wife and Metro.
So she is a Metro employee, and this would be part of the benefits package for a Metro employee?
Correct.
Is there a premium cost to have you and Emma added onto the insurance?
It is, and it's actually cheaper than my insurance at ARIA and better.
Do you have a ballpark of how much that premium
I do not.
is? The parenting classes, you testified not that long ago that you would follow this court's guidance on better communications with mother if the court came up with a plan. That could include parenting classes, yet you haven't done anything with the UNLV parenting class. Is there a particular problem with that?
Can I clarify that?
Sure.
Sure. When it was first issued, obviously there was a lot that was going on. I was pretty disappointed with the change. And then Rebecca really didn't handle her job.
That's Miss Fuller, your former
Correct.
counsel.
And then she wouldn't give me any information, stopped contacting me, would avoid my calls. And then I ended up letting her go. I came in here by myself. I had some classes for anti-terrorism that I did outside in Utah. When I came back, the October 1st shooting happened. I ended up leaving my job, getting another. I just simply forgot. There's no malicious intent on it. I just simply forgot until It was mentioned today, and I looked over and I said, shit, basically. It wasn't like I avoided it. I remember
Okay.
looking at it in the beginning, and then there was nothing in middle of November till the end of December, and there was nothing available, and I just forgot. I don't know what else to say.
On the Disneyland trip that you were talking about a little while ago, how old was Emma at the time?
3?
Do you recall if she had received all of her vaccinations at that time?
Seeing as how she had control of it, I don't know.
Would it surprise you that all of the vaccinations at the time were not completed?
It would surprise me, seeing as how adamant she is about following up.
Do you recall the measles outbreak of that year?
I remember a article she had sent me, but that didn't. As far as I know, the article had stated that it was already done and cleared weeks before we had even planned on going.
For the vision test for Emma, do you regard an optometrist to be a medical treatment?
I would assume so.
Do you think that that falls under your purview under the Missouri orders?
I do believe it does, and the only other stipulation was for dental, so I would assume everything else would fall under medical.
Did you notice anything about Emma's vision leading up to the eye exam?
I did not. She seemed perfectly fine, and her teacher agreed that it was perfectly fine.
Do you know whether she's farsighted or nearsighted? Do you know what her prescription is?
I couldn't tell you offhand, but I do have the copies of the paperwork.
Has she been wearing the glasses in your presence?
All the time, but I rarely see her wear the glasses with her. Never while she's in school, never while she's on FaceTime. I just never see it.
Well, they're sort of a new thing for a little girl. This current position, how long do you think it will hold for you? Is this a permanent one?
It's an open-ended contract.
Renewable annually, or is it renewable annually, this current contract, or is it an employment contract, or are you a subcontractor?
I'm a subcontractor under consulting.
So do you have your own LLC?
I do not. I work under Mayfield.
So you're basically a W-2 employee.
W-9.
W-9. Taxes are taken out?
No.
So you're responsible for your own
Correct.
quarterlies, your own quarterly taxes.
As far as I know.
And you're responsible for your own, basically, travel expenses back and forth.
Correct.
So really, you're like a business within a business.
Correct.
Okay. For the child dependency exemption, for what years did you use that on your tax returns? For the past 3?
2. I tried to file this year, and it says that my daughter's Social Security number has already been used by another party.
Did you receive the IRS form from Mother? That would be IRS form 8332.
Nope.
We can get you another one. We'll talk about that in closing, what's happened.
I don't even know what that is.
I'll explain it when we go through.
Is that the reason why it can't be filed?
If you have that form, you should be able to file for it. Your Honor, no further questions.
Anything else?
No, Your Honor.
Okay, you can have a seat. All right. Do you have any other witnesses?
No further witnesses, Your Honor. This would rest our case in chief, and I pass to Mr. Giavato, and I'm open procedurally to what comes next.
No other witnesses.
Do you have anything?
Yes.
Okay. All right, so then are you ready to close?
Yes.
Okay.
We, just to recap, we have some carry forward orders from the August 31 rolling into December, rolling forward, which dismisses or resolves many of the parenting issues. The final form of order, I suppose, would be a parenting plan or parenting order, because we already have a decree of custody from Missouri. So however you care to title that, we're open to it. It's all going to have the same information. The remaining issues for today are the making of medical decisions, medical and dental, that there be equally. Whether or not a hyphenation should be, well, actually, to make a finding of whether it's Baptista or Baptista as the child's last name, and then if it's in the best interest of the child, add a hyphen to resolve any, to clarify that. Week on, week off, the temporary timeshare to make that permanent, to continue the time window for phone calls, even though it's flexible and to accommodate dad's travels to and from Death Valley. To be careful at the exchanges so that we have the fewest amount of opportunities for conflict, basically keep the neutral exchange location. We're also asking for the school zone for mother. Regarding child support, we don't see that there's been a change in circumstances on the timeshare, and we're still within the initial 3 years, so we would not think that this would be a case for child support modification. The other problem is father has changed jobs and we have no current financial disclosure form. For medical coverage, we would just ask that premiums be addressed also when we look at the 30/30 rule. For tax, the final issue would be we would look for an equal sharing of the child dependency exemption. Mother had the child for the first 3 years, father's had the last 2, and we're glad to give him an extra form to help him file for this year. Then starting next year would be mother's first year for the child dependency exemption. For attorney's fees, I'll make an argument, but of course that's at the discretion of the court. The standard of proof for today is by the preponderance of the evidence, the greater weight of the evidence, basically. The burden of proof on the name change under Pettit versus Andreasen, best interest of the child without a burden on either side. And for that name change, we believe that as we go through the best interest of the child factors, that you have the power and the authority to clarify the full last name of Baptista with a simple hyphen. Also, that was an issue in the Missouri court and one of the issues that was on appeal. For change of custody cases, we usually approach the matters by placing burden of proof upon the party seeking a change. We don't know that there's really been a change in custody or in timeshare. The interpretation of the Missouri orders is something that I think you can make. I don't think that that is a question of fact, but a question of interpretation by you. And the case law for that is stated in our pretrial memorandum. Also, as a related matter, when we talk about recognizing the ongoing timeshare since the beginning of the orders, under Caldy versus Caldy, we have this equal sharing, first month on, month off, and week on, week off. Mother requests that the actual timeshare be confirmed as week on, week off, and carry that into the Nevada orders. For the best interest of the child factors, the first one, wishes of the child, if she's of sufficient age and maturity. Emma is too young for that. B, whether there's a nomination of a guardian for the child, that's not applicable in this case. C, which parent is more likely to allow the child to have frequent associations and a continuing relationship with the non-custodial parent. Mother has been proactive in trying to promote contact between father and the daughter. She encourages the evening phone calls, and she encourages love of father. Father is not favored by this factor. He has been rude and bullying at the exchanges. Until we got to the neutral location, there were altercations and the police being called. Your order straightened that out. And he has admitted that he's used undignified language towards mother, and some of those exchanges have been in front of the child. Stepmother has not helped this factor either by representing that she's mother for the ear piercing, or going to mother's place of employment under the guise of trying to modify the child records. She has no legal custody rights to go in and do those things. And that underscores the importance of the hyphen, because we have father being very clear that Bao is not the child's last name, it's only Baptista, and a stepmother actively pushing the child, what would be the bubbling into the mother's rights and duties as a parent. So the hyphen actually reinforces that mother is the mother of Emma. The level of conflict between the parents. Well, we've heard that recently it's been pretty good. And that's a good indication of the long-term impact of the week-on, week-off orders with a neutral location. This is actually progress from where we started a couple of months ago. And even though Father testified that feels fragile, our hope is that steadiness can continue under the current regime of timeshare. We're still of the mind that the least amount of parental interactions is actually best for the family, and that we should continue to use Our Family Wizard, or it looks like Talking Parents. That's on your desk right now. This is actually a less expensive program. Either one of those programs we would embrace for the non-emergency phone calls, and then for an emergency like the breaking of the wrists the other day for the child, if that be done by the quickest available means. The ability of the parents to cooperate to meet the needs of the child. Again, this is a high conflict case. In some ways it's extraordinarily high. Metro has been called the neutral exchange location helps. However, mother still has a certain amount of chafing at the school with the volunteering, even though it's a wonderful thing that stepmother is on the board, on the PTA board or whatever she is, whatever public role that she serves on this. But there has to be a certain delineation or respect of mother's timeshare. And that includes the ride in the morning, talking to her daughter in the car, getting off the school, watching her going to the door without being interrupted by one of the other parents in the non-custodial role. The mental and physical health of the parents, I don't think we've heard anything other than that the parents are healthy here. The physical, developmental, and emotional needs of the child benefits from consistent care and parenting. Clarifying orders from Missouri forward have helped that. Your joint legal custody definitions, what we've done with the exchange location, you've given us a good steady platform to work from. Also, the child benefits from the recharge time with mother following custodial time with dad. They're vastly different parenting styles. I believe that father loves his daughter dearly and that the daughter loves father. But different parents bring different mixes to the child, and some have more relaxed and stable attitudes in one than they do with the other. We think that that recharge time is with mother. Equal timeshare has helped the child. When we first started here in August of 2017, we had a fear of suicidal ideations, and you yourself said, listen, just to have those words spoken about, whether they're real or not, is a big cause for concern. Everybody pay attention. We took that to heart. We have not heard those things since, and the equal timeshare has helped steady the child. The nature and the relationship of the child with each parent. I think I've just spoken to that, different parenting styles, but I believe that both parents deeply love the child. The ability of the child to maintain a relationship with any sibling, that's a non-issue at this point. Bad news from the stand. It's our hope that maybe there'll be a little sister in the future, and our best wishes for that. any history of parental abuse or neglect of the child or sibling of the child. There are no prior abuse or domestic violence allegations since the 2016 Missouri orders, except for that little bubble with Child Protective Services. Our view is that that was really a positional CPS claim. Had it really been real, we would have seen a more intensive counseling go through August, September, October into November. It wouldn't have simply stopped because insurance stopped. A concerned parent would have kept that ball rolling no matter what the cost, wouldn't have bought new things, would have spent that extra money to make sure that the counseling continued. You did not hear that testimony from Father today about great sacrifices to make sure that the counseling continued. I think you can draw from that the inference that the problem was only temporary and it resolved quickly. Whether either parent or any other parent seeking physical custody has engaged in an act of domestic violence against the child, a parent of the child, or another person. Although Father has not smacked Mother, you have seen in our pleadings some of the language that has been used. It is vulgar and offensive, to say the least. That's still offensive language, and in a regular continuous form would give rise to a temporary protective order. Whether either parent or person seeking physical custody has committed an act of abduction. We haven't heard any testimony about that today. We did hear a little bit about the Disney trip, not being able to go on the Disney trip, and the issue of vaccinations. We have, and Father has stated he's got this ongoing fear of some form of abduction by Mother, but there's been no evidence presented to the court relating to that. Getting the child support. Rivera 2 requires a change in circumstances when assessing child support within the 3 years. Within the 3 years, with the continuation of the Nevada orders, there's been no change in the financial in the custodial circumstances, just week on, week off, equal timeshare, and Father's not in position to make any financial requests because he's changed jobs and has not updated his financial information. The UNLV co-parenting class, we ask that Father be restricted from filing any motions in this case until he completes that particular course. If he wants to relocate to a different city or change jobs or do whatever, or he wants more time with Emma, he's got to pony up to the bar and take the UNLV parenting class. Legal custody, standard definitions that we've included in our order, those are going to roll forward. We ask that those be ratified. For medical decision making, it's a bit of a rub. The Missouri orders are pretty clear that they wanted Dad to have only the medical and for Mom to have only the dental work. But what we've heard today from both parents is a discussion about, I didn't think my daughter needed glasses, but now she wears them all the time, at least in my presence. Mother saying that she was diagnosed as farsighted or nearsighted?
Farsighted.
Farsighted. So she needs glasses. One eye's a little bit weaker than the other. They've worked well in the emergency room for the wrist. You've heard Dad say in the last couple of weeks, it's been like an umbrella of goodness. We're actually getting along in some of these decisions. But the decisions are well communicated in advance about the joint nature of medical and dental care for the child. And for counsel this morning was making much ado about Mother violating the court's orders for the 5 and the 6-year-old wellness checkup. They weren't getting done. We believe that it was appropriate for Mother to push that appointment to make it go forward. And we heard from Father and from Mother that notwithstanding that action, that ultimate treatment would still rest with Father if something was uncovered during those wellness checkups. We do like the rule of three, and just to say that out loud, that is, if the first doctor makes a recommendation and it's disagreed, the other parent can go to a second opinion. If that still doesn't fly, then the third doctor would cast the deciding vote for necessary treatment for the child. The mutual behavioral order and our family wizard, they're good. We should keep them in place. Dad has been making some social media posts, but it's more about, it seems like it's mutated from about mother to the generalities of the family court system. In Nevada, there's a long line of people making those kind of complaints. As long as it's not about mother, we're okay with it. She needs the social media thing maybe should be cooled off a little bit. It's bad news, and it's something that promotes it seems to be promoting, it's either reflective of anger or it helps promote the anger for the social media posts. But it's certainly not helpful in terms of reducing conflict. For the last name of the child, I believe that I've covered enough of this with Pettit versus Andreasen. It's the best interest of the child analysis. The dicta in the case is clear that it is a burdenless review, meaning that either side can bring it up or the court can handle it sua sponte when making those clarifying orders on the names. Emma's just turned 6. She's not filling out any applications. She's not writing cursive. You've heard testimony that she knows about both names. The only one pushing the sole name is father. Physical custody, I think I've already addressed enough of this. Week on, week off is a healthy, it's resulting in a healthy and happy child. She's doing well. For the school zone, right now the child is registered in father's school zone. He's now working out of town. We don't know what comes next. We don't know what moves are in the future. What I would suggest is it's going to be more stable if first grade is in mother's school zone. That's the best interest of the child analysis under, I had the case name a moment ago, under the Arcella case. And even though the Arcella case talks about religious preferences and whether a child should go to Faith Lutheran or Bob Miller Middle School or whatever, what the crux of that case spoke about was addressing the school zone as a best interest of the child factor. And in looking at the best interests of the child factors, squeezing that in just like the name and just like custody, everything needs to be addressed with evidence that you've heard mashed into those factors. For the child dependency exemption, we would just say fathers had 3. We're glad to give them a Form 8332 for 2017 taxes. We have not taken that from father. We will send him a form through counsel that counsel can send on to his client. And we would just ask that we begin a rotation. So next year's tax returns, tax years ending in even numbers, be apportioned to mother. For attorney's fees, we've noted through the case today some bad actions on father's part, failure to complete the parenting class, what we perceive as bad behavior in the FMC process, insulting words to mother sent to her by email and text, splitting hair on the words on every order that brings a certain frustration of sharing Emma. And then after all of the words about Emma threatening suicide or hurting herself, a very quick bailout of the therapy. That was surprising. You've heard the numbers in the court today. We are probably going to hit close to $30,000, and that's with reductions of my time today. Others paid a majority of that. We leave it. If the court is inclined, you can either make a discretionary call on fees, or if you want to call one side prevailing, then we would submit maybe a Brenzel affidavit under Rule 54D if you're so inclined. And with that, thank you, Your Honor. I pass to Mr. Gibato.
Thank you.
Thank you. I think the first issue that needs to be addressed is what is the federal designation, because that matters. What determines then what the plaintiff's burden is. If we look at the decree or at the judgment concerning custody, it's pretty clear on its face that my client has primary physical custody according to that order. The order, although the designation is joint physical custody, there is a contingency that either party, if she moves within 250 miles, then the plaintiff's going to end up getting every 3 weekends, I believe it was, Friday to Sunday, and a Wednesday for 2 hours. That means my client has primary custody. Under Rivero, designation we ignore it. We look at Nevada law, and he has custody. So we start from that position. Then her burden is that she's got to show a substantial change in circumstances affecting the child's welfare, and then it's in the best interest of the child. What we have not heard is where there's a substantial change in circumstances affecting the child's welfare. There just isn't. These are petty issues that they have. They can't communicate. I think in a fair reading of this situation is that they're both at fault. They can't talk to each other. But that doesn't mean that the timeshare or that order needs to change because of that. It's not enough. It doesn't meet that burden. And I understand and I appreciate that counsel is trying to construe this as a motion to clarify. There's nothing to clarify. That's just saying that I want to modify custody. It's a custody modification in disguise. We have a clear order. The order is that when the parties are within 250 miles, she is a non-custodial parent. That's clear on its face. And that's in fact what happened when we moved out here up until this court changed those orders for about a year. He had primary physical custody. That is a fact. When we start from that standpoint, there is a higher burden that she has to meet that she has not met today. And so he needs to be designated a primary physical custodian. My client does, defendant. And the order that is established in the Missouri judgment needs to be affirmed. And that's the order that needs to be going forward. Right now, week on, week off, that's a temporary order that this court entered. He shouldn't be penalized because that happened however many months ago. And even though things may be going good now, 6 weeks before trial, that's a positional attitude, positioning yourself for trial. When they're sharing custody. The reason he got primary physical custody is a very good reason for us, because she is difficult. And he got primary physical custody. It's that simple, in my view. There's nothing else to discuss. He has primary physical custody. She hasn't met her burden, and that's what I like the court to order today. That's all I have. As far as the name change, I'm sorry. As far as the name change, I agree with you that it's Baptista is the way that it. But I think the hyphenation was specifically addressed by the prior judge, and he declined to hyphenate it.
You think it was, or you know it was? Do we have a transcript?
I think there was. I think with Chance, he told me there was some testimony on that today, and maybe in the orders. No. All right. Well.
Well, I mean, they talked about it, but we don't have a transcript. Everyone has their own interpretation. Right? I mean, I didn't hear anything.
I would have, okay, so look at it this way. If the judge wanted to hyphenate it, he would have. And now that issue is precluded. That's it. They want to raise that issue again. That issue should have been dealt with then. It was not. There's no hyphen there. That judge could have put it if he wanted to. He did not. And we're relitigating the issue under a different set of standards. But the reality is the issue is precluded. That's what I stand on.
Okay.
We submit, Your Honor.
You know, neither one of you really specifically pointed to anything in the actual original order about whether they have joint or whether they have primary. So I'm going to give you a couple minutes. I'd like you to literally go through the order itself.
I'll tell you, I mean, yeah.
So whoever wants to go first.
It's actually in Rebecca Fuller's meeting. She states it right there. And
I'm asking for this.
If you look on the plaintiff's exhibits, page 26.
26 of the order. Okay. So,
Starts at the last paragraph at the bottom.
okay.
What page are you on?
Page 26.
Go ahead. So,
In the event that father moves within 250-mile radius from Joplin or mother moves within 250-mile radius of Vegas, visitation will be modified as follows. Mother shall have time Wednesday evening from 6 to 8, as well as the first, third, and fifth weekends from 6 on Friday to 6 to Sunday. What happened, that is now what continued to happen until this court changed that order.
my question is, where does it say primary?
No, it doesn't. That's the point. That's the problem. It says the designation is joint physical, joint legal. But what I'm saying is under Rivero, when any party moves to modify it, the court specifically directs the district court to look at Nevada law to interpret what the designation is, not what the parties actually state. That's specific. That's clear in Rivero. And
What the judge actually states is what I'm talking about, not the parties.
Your Honor, with your
I'm
indulgence.
trying to, well, let him finish though.
Sure.
Okay, so that's why I'm trying, it's hard to interpret. That's why I'm asking you to actually talk about the order itself specifically, because it's replete with findings that they have joint legal and joint physical custody.
it is. It is.
That's why I'm asking.
Yeah, so at some
This is
point-
important.
It is. It's very important. The last provision, in my view, the way I look at it, the last provision that applies here is this one. This is the provision that contemplates a move, because that's what was going on. The parties were contemplating a move. That's what happened. That's what triggered this provision. Every other provision after that one's triggered, in my view, is no good anymore. There was one provision where she'll have 1 month, and then he has another month, and then there's another provision. It's all over the place. But this provision applies now. That is the provision that is triggered now, because that's the eventuality that occurred. What occurred was she moved to Vegas within 250 miles of him, and that's where the kid was, by the way, with him. And that's what was actually happening when she moved in October of 2016 until this court changed the order. Under Nevada law, when you look at Rivero, you disregard the designation, and you look at what the timeshare actually is, and you determine what the designation should be based on that. So when you look at it like that, you start from that premise. The standard's way higher. It's under Ellis, and they haven't met that burden. There's no substantial change in circumstances affecting the child's welfare. This case shouldn't have even gone forward in the beginning, in my view, in my humble opinion. But here we are.
Your Honor, I have some citations for you. At the bottom of Exhibit 1, at the bottom of page 20, begins the judgment of custody and support. And the text begins in full on Bates Stamp 21, and I'll read it out loud. It is therefore ordered, adjudged, and decreed that the parties are hereby awarded joint legal and joint physical custody of the minor child, with the respondent's address designated as the address of the child for education and mailing purposes in accordance with the third amended parenting plan. And please let me finish. And then goes on to say filed and served. Then right below that is a blurb from the amended parenting plan definitions. Petitioner is Christy Bell. Respondent is Andrew Stephen Baptista. 3 is child. Then it starts under Section A, legal custody. Let's see. And this is where joint legal custody is defined, and it says at the bottom, the parties will jointly decide the following: educational instruction, religious instruction, health care, discipline, child care providers, extracurricular activities, and 7, all significant decisions affecting the child's growth and development. That gives us joint legal custody under that. Then as we go to physical custody, we had, until the child began school, joint physical custody with month on, month off, and then the second order, what would be Exhibit 2, modifies the first order, and it says on Exhibit 2, Bates Stamp 37, first full paragraph, courts finds petitioner, that's Miss Bell, will be moving to the state of Nevada on October 7, 2016.
Page what?
37. That would be Exhibit 2.
Oh, sorry. Thank you.
That's the follow-up order. Mother petitioned the Missouri court and said, I'm moving to Nevada. Can I still have joint physical custody? And this is where the rubber meets the road. Court finds mother will be moving. Therefore, the court orders, upon the parties' agreement, petitioner shall receive the child, and then it starts to go into a timeshare. Let's see. At the very bottom of page 37, the parties shall continue to exercise a weekly alternating visitation schedule from Sunday 3 p.m. to Sunday 3 p.m. At the top of page 38, the parties shall note that it was not the court's intention to cease the month-to-month visitation until August 2017.
And that's when the child was starting school, right?
Right, and that's when we ran into the situation of the child saying, I don't feel loved, I think I might hurt myself. CPS reports coupled with therapy, that mishmash, and that's when we were first before you. And that's when you issued the temporary order to continue the week on, week off. Did that help?
I mean, I think he might want to respond.
Sure.
I'm just waiting.
Just give me 1 second, Your Honor. So the understanding is this, and I don't know where this or why it came out this way, but the thing is that the initial...
You don't know where what is? What are we
how
talking?
it issued, how this order that he just referenced issued, but the fact is that the parties, when she moved out here, they continued to follow the previous order that I just cited. That was the testimony. It wasn't rebutted. I'm not sure if she's saying now that that's different, that she had a week on, week off, because that's not what it was. And again, we go back to Rivero. You look at what the parties, what Nevada law says, and under Rivero, even under Bluestein, when the parties have a de facto situation like that, you look at what they actually did, not what the designation is. If the designation is joint, but the parties actually exercise a primary physical non-custodial parent situation, that's how it is. That's what it's going to be. That's what we have here. That was not rebutted. That was she moved out here. She had every 3 weekends a month and a Wednesday until this court changed that order. If she says different now, I'd like to hear. I don't think she said that's the case.
When did Mom move here?
Mother moved here in October 2016.
Okay.
And starting then, the testimony consistently of both parties was week on, week off from that point.
That he just testified the opposite of that.
Okay, so what about this order, Exhibit 2? I just want to give you a chance to talk about it before we finish.
Yeah, like I said, it's an order, and according to the order, it appears to me to be a week on, week off schedule, but it's kind of unclear. I guess you can interpret it. Intention to cease the month-to-month visitation for August. My understanding of my client's testimony when he was on the stand, I asked him specifically about this when she moved out here. What was the arrangement? She had her every Wednesday, and then 3 weekends a month. That was his testimony, and he's here. He could tell you again. I don't know. You want to ask him, but that's what he.
I want your interpretation. I just want your position on the record about this order.
My position on the record is based on his testimony. That they were following that previous order that had that contingency on. I see that there's a subsequent order that issued some 4 months after that. But based on his testimony, the fact is we're still in the same position that under Nevada law, under Rivero and Bluestein, he had primary physical custody of the child until this court changed that order. And because he had primary, it's a higher standard. That's the position I'm going to take.
So I just want to be clear, because I think before you said the order from Missouri gave him primary custody.
It did, and then obviously it seems like some subsequent order changed it.
To joint. So now I just want to understand. I'm not arguing with you. I'm just clarifying. So now the position is that even though this order gave them joint custody, that the de facto situation was that dad had primary.
But
And
see,
that's what you want me to
let me-
find?
Let me clarify. This is complicated. This order is a mess. The reason why it is a hot mess. The reason why that subsequent order issued, the intent, I think, of the court was that she have time with the child until the child started school, which time primarily resided with dad.
Well,
We should probably what would be a good idea, Your Honor, is if we can get the transcript and the record of what the proceedings were, why these decisions were made, and then brief it, and then you can make a decision, because this stuff matters.
yes, it does, and that's, we've been set for trial. Now this is what, our second setting?
You don't have to
I
say
haven't
whether-
gotten any documents from the defendant's side. So now you're asking to reopen discovery after we've held the trial.
This is a
I don't think
purely
that's-
legal issue. This is purely a matter of law. The record's already what the record is.
Okay, but counsel, all right, okay. All right, so do you agree that this Exhibit 2, the subsequent order, gave them joint custody once mom moved to Vegas?
Just until the child started school.
Can you tell me where it says that in the order?
It doesn't say it in the order. That's the problem. But that was the intent of the parties. She's here. She can testify. If you ask her that question, then we can resolve some of this. Unless ask her, here she is. That was the
She
intent.
was here this morning on the stand.
Well, I wasn't.
No, you weren't. Okay.
But that was the intent, and then that's why otherwise it wouldn't say in the order that it's not the intent of the parties for this to go past August. So here's this. If it says
Where does it say that?
It does say that.
It
Now I'm not
says
making stuff up.
the parties shall note it was not the court's intention
Right.
to
Where to go?
cease the month to month until August,
Till August. So
when they
what
were
happens
living
after?
apart.
So what happens after August? It should revert back. That's where you can glean from that order that there was some prior understanding. This is what it's going to be until the kids start school, and then we go back. That's where you could see that. Otherwise, why is it there? Why does that exist? Why would you have that? If it was permanent, if that's how it was always going to be, there would be no limiting instruction. That's what that is, a limiting instruction. Poorly
the other-
worded.
The
Very
other
poorly
question
worded.
would be, why didn't they just say dad has primary custody at that time?
Why do
Because
orders?
it's a change of custody.
Why are orders drafted the way they are? Why are they always?
All right, now we're getting philosophical.
That's what
All
we
right.
have here, but we have a limiting instruction. So what happens? So then ask yourself this: what happens when that eventuality occurs? What happens after August of 2017? Where do we go? We go back to the prior orders where we go. That's the only order that exists that doesn't have a limiting instruction. We go back to the idea that my client has primary physical custody.
I don't agree with that, but let's bear that out for a moment. Let's say that you do go back to the prior orders. At that point, both Missouri orders were domesticated in Nevada, and this court could treat those as its own orders. And then you overlaid on top of that your August order, which then became the December 7.50 order, except for the open issues before the court. So it's a bridge too far to jump all the way back to 2 years prior to what the other order is. Once everybody was in Nevada and we domesticated it here and we argued under Nevada law, which the other side has been touting, citing to today in his closing arguments, we had jurisdiction over everything. And at that point, we had the power to use the preference for joint physical custody, which is consonant with the secondary order from Missouri from October 2016. There's no divergence in the law, there is consonance in the law.
I'm looking at that order, that series of fouled up orders as if they were issued in Nevada, because that's what happens when you domesticate them. They're Nevada orders now. Now we have a motion to modify custody. This current order that we're laboring under is a temporary order. They're asking to change the custodial arrangement. What are they pointing to? These prior orders. We got to figure out what order applies and what does it mean, because they're a mess. There's what you're trying to look at now is an order that has a definite limiting instruction on it. There's no way to look at that but to say that the court considered some fact that they had in their mind that said that after this period something's going to change. We don't know what that is apparently. So I was saying it would be instructive, even though I understand your position. You're probably mad at me, but maybe we could give it or we could brief it.
Why would you say I'm mad at you? That's
Well,
not fair.
because you said I didn't. We've had all this time. We should have submitted these briefs.
That's not being mad at you. That's just stating a fact.
We can
for the record.
Well, it's a bit of a hot mess. I didn't consider this until I started really looking at it, and it'd be helpful to look at the record of what happened in these hearings. It would fill in the gaps. We could brief it, and you can make a decision as a matter of law. This doesn't require more testimony because that changes everything. Then you know it. You're looking at it. They don't have a case. That changes everything.
Specifically, what you want to do? I want to understand.
Just get a transcript of the proceeding from which this order issued. Because then that would fill in the gaps. Why is this limiting instruction there? Was it the case that the intent was that once the kids start school, we're going to revert back to some old order? Why is it there? Because otherwise we're trying to just guess and speculate as to why it's there. It's there. What do we do after it? And now it's all just guesswork. Maybe we can glean some information from that would be helpful to the court. It would just require a brief, a decision issued after the court.
Your Honor, you've already ruled on that request. When we were setting up in August of 2017 with Ms. Fuller at counsel's table, you were clear that we were looking at changes of circumstances from the move from Nevada forward, that you were treating the Missouri records as final custody orders, and that we were just looking at them as the baseline, and that the consideration of the court today would be for any new issues. Our side has presented all new stuff. The other side has presented, they've been trying to work the details of the two Missouri orders, but those are already res judicata and resolved under McMonagle and Hopper, and under Castle too, because all of these allegations were litigated to the full extent in 2016 and 2017. So it's your right as the sitting judge to now review the orders and interpret them as a matter of law. Those citations, again, are in the pretrial memorandum for the authority that you can treat these as interpretive orders and that you are not required to go back behind the curtain under McMonagle and Hopper, because those are already litigated cases. To go back to the transcript of those is what we would never do in Nevada law on another custody case.
Your Honor, I think he's misunderstanding what I'm trying to say and what we've been talking about, actually. I think you get where I'm going. What he said is entirely correct. Whatever series of facts that we use to make a determination of whether you're going to modify custody, you have to go from that prior order, from the Missouri order. Sure, okay, great. But what does that order mean? That's what we're trying to figure out. What is the standard? Because what that Missouri order means, what it is going to determine what standard you look at these facts, you apply these facts to. That is what I'm saying. That really matters. Because otherwise, in one case you have a best interest standard, and in the other you have a higher standard. And what I'm saying is that you definitely have a situation, if you look at it on its face, where there's a limiting instruction to one order that seems to point back to the last order that's in effect. And what I'm saying is a review of the transcript of that proceeding that order issued from may shed some light on that. And then everything he's saying is correct. I'm not disputing the fact that the facts that have been alleged since then and all this other stuff that's come up today. Then you can use those and apply the right standard. That's all I'm saying. Am I not making it sense? If you have any questions.
Today is the day for trial. They blew every opportunity on discovery. I could have reopened. I could have gotten a stipulation to reopen
I
it.
could also file a motion to reconsider.
Let him finish his sentence. You don't let people finish their sentences. I know you're so anxious to tell us. Go ahead. Do you forget what you were saying?
Today is the day for trial. Discovery's been closed for a while. Everything that was meant to be presented was presented. can't help that at the end of the trial, they now wish they litigated a different case. But they didn't. They played the hand that they wanted to play, and now they want to play another hand. And that's inappropriate at this stage of the case. We ask for your judgment.
In the first place, I'm not asking to reopen discovery. This is a record, it's a court record that I'm asking about. You pull it and you submit it, and then you make a decision on it. It's not doing discovery. I'm not trying to dig up facts. It's not a fact that I'm trying to dig up or discover. This isn't discovery. If I had this case from the beginning and I looked at these orders, that's what I would have treated it as an appellate matter, got the record, figured out what this mess of an order meant, and then said at the initial stages, in opposition, you have no case. This claims that you're looking at the wrong standard.
The cost of the transcript is
Let him
complete.
finish. Let him finish.
So that's the point, is that in order to make the right determination in a really important matter, it would be helpful to this court. It's entirely up to you, Your Honor. It is incredibly helpful, I think, to this court to have the transcript of that proceeding. You don't even have to brief it. You know what I'm talking about. Provide you the transcript, look at it, and make a decision.
Okay. Well, as I noted before, discovery is closed, and there was no, and I'd have to note that the request for this transcript was done after everyone did their closing arguments, and then I just asked for you to give me some more specifics about the orders. So this idea came up after really everything was closed, and I was just asking for some clarification. And as much as I might have liked to have had the transcripts, I think that really it's too late in the record to do that. I'm certainly going to have to look at both of these orders very closely again. And I know that the judge took a lot of time to write that first order, but there are some inconsistencies, so I have to read it again. And then I have to interpret where we go from there. So, with that, I'm going to set it for decision in 3 weeks, which is the 16th of May at 9. I don't anticipate that you will have to come to court, because my goal would be to give you a written decision before that date. I'm just setting it out for decision just in case, or if I want to come back in and explain to you certain things on the record. If I need some more information, we'll use that date, but you'll know ahead of time, because we'll let you know if you have to appear. So that's May 16th at 9 for decision.
Would you accept a briefing, nothing added to it, just legal briefs, on the interpretation of these orders?
We oppose that, Your Honor.
How to interpret them, what principles to use?
I couldn't hear what you're saying.
Say, just briefs to discuss how to interpret these orders, what direction to take, the principles to use, maxims to use, things of that nature. It's entirely up to you. I'd like to brief it. He doesn't have to. He doesn't want to.
Nevada law gives you full discretion on how to use the plain language of the orders. You don't need a further description or a transcript. A transcript, by the way, would be in the thousands of dollars for several days.
Well, he's not talking about transcript. He wants to brief it. He wants to argue again, right?
Just on that very
You
limited.
want to argue a little bit more.
A little bit more, just on that little limited issue. That's it. Because they're a mess. It's not a plain language. There's no plain language there. That's the problem. You're stuck with a difficult decision, no doubt. I don't know that the transcripts would have helped, but we have conflicting orders. Really, one's limited, one's got a limiting instruction on it. What do you do with that?
All right. At this point in time, I guess now the burden's on me to go through it and interpret it the way that I think is appropriate. And then if you don't agree with that, obviously you're free to appeal it. But I really have to look at these orders again and wrap my mind around it to know what the right thing to do is. So with that, we're set for decision, and I thank you both, counsel, and I wish you both good luck to the parents.
Thank you. Maintain the current orders until.
Absolutely, nothing changes.